Good afternoon, everyone who's joining us. We're just going to give it a minute or two to let all the attendees funnel in.
Better.
Okay. Good afternoon, everyone. Thank you for joining us. I'm Matt Vallière. I'm the Executive Director of the Patients' Rights Action Fund, or PRAF. I'll be your host today. For the benefit of some of our allies with disabilities, I'm a late 30s man of color, dark wavy hair, dark trim beard, olive complexion. I'm wearing a purple crew neck sweater and a purple checked shirt, and I have a gray fuzzy background. We'll have three panelists for you today who will provide an in-depth legal analysis, implications, and next steps given the recent settlement between plaintiffs and the state of Oregon in the Gideonse case. We have for you Kara Janssen, who is the senior counsel with Rosen, Galven, and Grunfeld, a firm in San Francisco. She works on complex litigation with an emphasis on civil and disability rights law. She's been a staff attorney with Disability Rights Legal Center and with Disability Rights Advocates, both national nonprofit legal centers, where she was lead attorney on multiple individual and class action matters on behalf of people with disabilities. She's a frequent speaker on legal issues relating to the criminal justice system and the rights of people with disabilities. We also have Conrad Reynoldson, who is the founder and vice president and lead attorney at Washington Civil and Disability Advocate, a Seattle-based disability rights and civil rights nonprofit guided by the simple but powerful proposition that all people have equal dignity and worth. Conrad and WCDA are committed to providing legal services to people with disabilities, regardless of ability to pay, and increasing accessibility and inclusion in Washington State and beyond. And finally, we have Dr. Jeff White, who practices cardiology at the Willis-Knight Medical Center in Shreveport, Louisiana, where he served as the chair of the Institutional Ethics Committee for over 20 years. He's a past president of the Shreveport Medical Society and a former delegate to the American Medical Association for the Louisiana Medical Society. Dr. White has been a tireless advocate on end-of-life care and in opposition to assisted suicide, as fundamentally contrary to the physician's role as healer. He also sits on the board of the Patients' Rights Action Fund. So we have an ALS interpreter for those who would benefit from it. A little housekeeping. We're going to take questions via the Q&A function. So if you move your cursor around a little bit, you'll see the toolbar at the bottom. At the far right, there's a Q&A with two little bubbles. You can push that to be able to input your question. Please type it with your name, organization, affiliation if you have one. And if you're from the press, please advise which outlet. For media requests, please contact Bill Pierce at WPIERCE@apcoworldwide.com. That's APCO worldwide.com. This session will be recorded and we'll share the link on our platforms afterwards. For the panel and hosts, anyone who's not speaking, please do keep your mic on mute. And if you could benefit from closed captionings, here's how to turn them on. Again, move your cursor around. At the far right of the toolbar, there's a live transcript with the CC logo on top of it. If you click it, you can push the button that says show subtitle. You're also able to access the full transcript if you push that, and subtitle settings allows you to increase or decrease the size of the closed captioning. And there's a live closed captioner for accuracy's sake. Okay, so Kara is going to provide for us a kind of legal analysis. Again, Conrad will give us a perspective on how this will affect people with disabilities. And Dr. White is going to talk a bit about how this settlement may impact the practice of medicine in other states, legal and not legal, and how telemedicine may interweave with these questions. So Kara, please take it away.
Thank you, Matt. I appreciate that introduction. And before I go further, I want to just describe myself in case there's anybody with a vision disability who's watching this now. So I am a woman in my late 30s. I am white skinned. I have on a maroon dress and my hair is back. I'm sitting in an office with light streaming into the windows, and you can see my calendar behind me, which has a photo of the Golden Gate Bridge at sunset, because I am in San Francisco right now. Hopefully, for those of you who can, you can see my slides that are up right now. Matt, can you confirm are those slides showing?
I can see your slide, and it may be helpful to folks if you look in the upper right corner, there are options to view. The easiest for seeing a person's slideshow and their slide are side-by-side speaker. If you benefit from the ALS interpreter, you want to put side-by-side gallery or standard, and then scroll to the interpreter.
And I will go over the content of each slide. So this first slide here has the title of the presentation, my name, Kara Janssen, and the firm, Rosen, Galven, and Grunfeld. It also has my email address. If there's anybody who has any questions after this, of course, you should feel free to reach out for Matt. And then this is also my address, kjanssen, JANSSEN @rbgg.com. So I'm going to give the sort of what happened, why are we here, why are we talking at this webinar overview of Gideonse and what's happened there, before everyone else goes into some more of the kind of interesting implications of this. So one of the most interesting things about this case really is its duration. It was filed on October 28th of 2021, and it was dismissed and fully settled by March 28th of 2022. So not very much time passed between those two events. This was brought solely by a physician and named multiple defendants: the governor of Oregon, the attorney general, the director of the Oregon Health Authority, the executive director of the Oregon Medical Board, and the Multnomah County District Attorney, who were all named in this suit. It is worth noting that the governor and attorney general were voluntarily dismissed before the settlement, and they are not parties to the settlement. So why did the doctor bring this suit? So he brought this suit, and the way the complaint is drafted focuses on the fact that his clinic is located near the border with Washington. He has patients who reside in Washington, and he wants to be able to offer them services under Oregon's assisted suicide law, but he cannot because the Oregon law, one, does require somebody to be a resident, and also one of the forms that the physician submits requires them to check that they have confirmed that in some way. So the lawsuit alleges that this residency requirement violates the privileges and immunities and commerce's clauses of the United States Constitution. This slide also lists the specific Oregon codes in which the assisted suicide law is codified in. So of course, the assisted suicide law is passed, that is then codified in a set of different codes. And so this, he alleged that each of those codes that reflected the residency requirement violated the US Constitution. So the Privileges and Immunities Clause provides that the citizens of each state shall be entitled to all privileges and immunities of citizens of the several states. Basically, you go from one state to another, you should be able to get whatever residents of that state can get in general, the benefits, I suppose, that are offered to people in that state. They also included a claim under the Dormant Commerce Clause, which is a clause that essentially prohibits anything that overly burdens interstate commerce. So again, he wanted to provide a relatively straightforward case, wants to be able to offer this to his clients who are in Washington, and alleged that this is the only medical procedure that he is categorically excluded from offering to those patients. So this may have been a very interesting case. There's a lot of really interesting legal issues here, and it's unclear exactly how they would have all panned out, but nothing was actually litigated in the case. There was no answer filed to the complaint. nor was there a motion to dismiss. Essentially, what happened in the case is it was filed. There were a series of extensions that were granted to defendants in terms of when they would have to answer or otherwise respond to the allegations that the doctor raised here. But none of that ever happened. They just entered into this settlement, which sort of sweepingly got rid of the residency requirement with no input from the court and no input from the community. And the settlement, which was filed publicly, and I believe Matt can make available to anybody who does not already have it from the materials. It actually attaches the internal directives that were issued before the settlement was entered. And the settlement was filed with the court on March 28th. But internal directives had already been issued by the district attorney as early as March 8th, the medical board on March 18th, and the Oregon Health Authority on March 21st, that already rendered the residency requirement unenforceable, even prior to the settlement, of course, being filed. The settlement does require the state to actually try to change the law, right? So one could look at this and say, well, this seems like a huge circumvention of the role of the people here, because this happened literally behind closed doors, out of the sight of the court, not in front of the legislature. So the settlement does include that they must put forth a legislative concept, which is included in the settlement, that will strike the language from the actual statute around residency, and it will take it out completely. So as part of the next regular session, that should be put forth. If that does not happen, or if any of the entities, the district attorney, the medical board, or the Oregon Health Authority change their position on any of this, then the agreement allows for the doctor to sue again. So that would be open if anything changes. But of course, nothing in the agreement binds the legislature to pass the amendment, nor could it. Courts cannot order the legislature to amend the statutes in that manner. So we will have to see what happens there. I want to briefly go over the residency requirements and the right to travel that this implicates. Again, like I said, there are some very interesting issues that are raised here, but nothing was actually litigated. As I mentioned, the Privileges and Immunities Clause is intended to ensure that a citizen of state A who goes to state B can get the same privileges. And there have been a variety of laws that have been struck down under these sorts of provisions. I have a couple of examples here. For instance, you cannot charge non-residents 100 times as much for shrimp. You cannot have hiring preferences based on where somebody lives. You have to look at whether or not there's a classification, burdens and activities sufficiently basic to the livelihood of the nation, and whether it's closely related to the advancement of a substantial state interest. Now, one thing that's really important for folks to think about here, the fundamental right at issue is that right to travel between states, is really how this is generally framed, right? And so the fact that the residency requirement here is being removed, that does not mean that residency requirements and all of the other statutes are automatically null and void, for several reasons. One, there was no judicial decision here that said this residency requirement was inappropriate. And then the other reason is because the way Oregon defined residency for purposes of their assisted suicide law did require certain proof, including a driver's license, property, taxes, the statement that you lease or own property. While those may have been appropriate, I think it is very possible a court would have upheld those as okay. Other states' residency requirements may vary, and a residency requirement that merely requires somebody to live in the state and intend to remain there, those types of requirements have been upheld in other cases. So I want to make that point, but again, it was not litigated here, so there are certainly a lot of questions that remain. The last bullet point here just again notes that the fundamental right at issue is not a fundamental right to access assisted suicide, which we know does not exist, but it's that right of travel between the states that is sort of the issue that courts look at when they're examining these sorts of of cases. And all of the states, Oregon now will be the first that will not have it, but all of the other states that legalize assisted suicide do require you to be a resident of the state at this time, at least. Again, this is what I was just sort of going over, that there is the courts distinguish between residence requirements that get very specific, that have durational requirements, require you to have purchased a home or something like that, to have been in the state for a certain period of time. Those often do get struck down, but a basic residence requirement that you must live and intend to remain in a state, those types of requirements have been upheld, and Oregon actually applies that requirement to its Oregon's health plan, for example. So before we go into the other presenters, just some general questions and implications that I'm sure there will be time to go over in more detail in the Q&A section. But of course, what does this mean for the states that are nearby? The complaint focused on Washington, and we know Washington is a state that has its own assisted suicide law. But what about states that don't have these laws? What can they do to protect residents in their states? And what does this mean for people who are traveling back and forth between those states, who are bringing the medications across those borders? What does this mean in the context of telehealth, as Dr. White is going to discuss in more detail? What happens if somebody ingests it in the home state? So we'll talk about this more, I believe, at the end. But one of the big things that states can do now, states who want to ensure and protect their residents and ensure that they're not pressured into these sorts of decisions, is to make it very clear within your own states, licensing schemes, regulatory schemes, criminal enforcement schemes, that any actions taken in furtherance of aiding or assisting anybody in committing suicide, that those are punishable, that those will lead to sanctions, that there are clear prohibitions and punishments outlined in the state laws of the home state to protect whatever happens within that state from these larger issues. I've probably, I think, spoken for a bit more than I needed to, so I'm going to give my time to the next folks, and we'll get back to these implications at the end, but there are a lot here.
Great, thanks so much, Kara. Really appreciate your legal analysis and expertise on that, and just kind of really unpacking what happened, because it for those of us that don't practice law, it's definitely a little confusing and feels like there was a bait and switch, that the justice system didn't actually work the way it normally would or is supposed to. So I'm grateful for your outlining all of that for us. Thanks. I have a couple questions for Conrad at this point, and I'm just kind of, for me, my mind is kind of exploding with all of the potential harms and dangers that this presents to people across the country, where anyone can hypothetically go to Oregon and get these drugs, and it doesn't necessarily even need to be from America. It could be from other countries and fly to Oregon and receive this. So, Conrad, from your perspective, are there particular dangers to the disability community and people with disabilities with a shift in the residency enforcement that you would see as particular difficulties that the community would face, and how could those kind of constituent specific dangers be addressed?
Yeah, so I'm of a couple minds here with this as far as the degree to which there's the danger, but it's clear that there is an increased danger here. And so I think before I go into that, again, maybe just to kind of reiterate a little bit of what we've talked about so far and add a little bit more to it. So, it is clear that, this is going to make it easier for people to utilize the law in Oregon. And I guess the questions really come up as to, what degree it's going to change things from where it was before.
Right.
And so, we don't really know how much medical tourism was happening, prior to this. We know that it will increase it. And so I think that's another open question. But I think it is important to remember that, the patient themselves is still required to actually obtain the prescription within Oregon. And that, they are still required to provide a written request to their physician, signed in the presence of 2 witnesses. And, if the patient were to take the dose that's prescribed under the assisted suicide law, they're outside of the state where it was obtained, then they would, and those involved with it, lose the legal protections afforded by the law in question. And so, the death would likely be ruled a, assisted suicide under another state's law, where in some cases that can be prosecuted, and that there may be other repercussions as well for the prescribing physician. And so I think that might be something that's litigated in the future. And then, I think it's also important to remember that, controlled substance laws may be in play here too, and could be helpful in preventing this from being as bad as it would otherwise have been. And then, like we alluded to earlier, we're still trying to figure out how telehealth will change the practice of things, where, it's somewhat in flux at the moment, just with the emergency rules that are currently in place, and when those are going to be relaxed for practicing across state lines. And, different states, they're expiring at different times. And also that Compassionate Choices has been pushing to, modify the telehealth rules permanently to allow consultations and prescriptions across state lines. And I think that would be an even greater concern in light of what's happened now in Oregon. And so, turning back to the disability community more specifically, though, on the one hand, it's been, outside the context of assisted suicide, a very positive thing with the disability community and telemedicine, and,
Right.
for example, being able to see specialists for certain conditions in other states where you might not have one. But at the same time, we have the concern here now, and making it easier through telemedicine in order to, take advantage of the change in Oregon. Yet at the same time, as I mentioned, the patient would have to still travel to the state to fill the prescription, for example. And generally speaking, from experience myself with a physical disability, that, traveling, for example, across the country just for that can logistically definitely be a challenge for many people with disabilities. And so I think that might mitigate the danger here, in that just it wouldn't be, utilized as much because of logistical considerations like that.
Right. Yeah, I'm thinking too, as we've seen in recent weeks, some doctors in legal states are prescribing lethal drugs to patients with psychiatric disabilities like anorexia. There are patients every year that utilize the assisted suicide laws when they use the underlying condition of diabetes,
Right.
perfectly treatable illness. So in terms of folks with disabilities, that it would be fairly easy for them to travel, and or maybe for those states that are kind of more close to Oregon, maybe that would be where the increased danger comes from, and just kind of a greater openness to come who may. What do you see this as kind of a precedent setting moment where we've seen since even just before the settlement that, Compassion Choices is pushing for a broader removal of residency requirements across those states that have legalized. Where I live in Massachusetts, it's not legal here, but you have states pretty close by. Vermont for me is about 20 minutes away.
Yeah.
So just thinking about that and how that would affect folks with, a variety of disabilities, where it would just be almost like nothing to go across the state line and, access this, and how the pressures that people with disabilities face from a kind of a society that devalues the lives of people with disabilities. The removal of a residency requirement would just maybe make it that much more easy, and set up less roadblocks, I guess physically and literally.
Right.
So any other
No,
thoughts?
I would agree with that as well. And I think especially in instances such as what you just mentioned, where the states are much closer together.
Mhm.
And I think maybe wouldn't be the same, I guess, level of concern if it's maybe a little bit further away.
Right.
But definitely, in an instance like that, if somebody's in Massachusetts, how easily they could get to Vermont. And so I can certainly see, that concern there. I don't know if I would add anything further as far as, I guess, specifics on protections versus dangers beyond that.
Mhm.
I think it's more just kind of a general concern and a general making it much easier to be able to, utilize assisted suicide in a nearby state. I think that's probably the biggest concern.
A lot of people have, been asking like, well, what does this mean for us? And I think that's part of the reason why we came together on this webinar is what does it mean? As far as I can tell, there are a whole lot more questions than there are answers. And how is it that physicians are going to approach this? Those who are in Oregon and outside of Oregon, who have licensure in Oregon, but who don't actually reside there. How does telemedicine work with that? And I know Dr. Weiss can cover that, but I'm thinking even like what you mentioned earlier, Conrad, about somebody going to Oregon, getting the drugs, going back across state lines. How does that impact the way that those states, both advocates in those states, people who are advocating for the rights of people with disabilities and equal suicide prevention care and services, and whether or not those people that were involved in the assisted suicide process in Oregon could be held liable in the state in which the person ends up taking the drugs across state lines as an act of bringing those drugs there in the first place, but also, whether or not the physician involved could be prosecuted in the state where the drugs are taken, that kind of thing. So those are all big question marks. I don't think we necessarily have answers to those questions, but certainly concerning.
And I don't want to be overly cynical about it, but just from experience in Washington State, we do need to consider the role that prosecutorial discretion plays as well.
For sure.
Because, they haven't been complying with our own state's law with people in our state to the point where, technically the assisted suicide would, more than qualify for potential prosecution. And yet, that hasn't happened. And I don't think it will happen in our state. And yet in other states, perhaps it might be different, but in this state, even when they're clearly not even turning in the legally required forms to comply for residents in our state and not facing any kind of prosecution, it's just uncertain as to whether that would actually ever happen.
Yeah. So, and that's a good segue point for Dr. Jeff's piece on telehealth and how, whether or not, the laws surrounding telehealth will actually end up being enforced. That's kind of a different question, but just Dr. Jeff, could you kind of go over with us how telehealth works currently under the difficult rules, or the not difficult rules, but with the difficult situation of the pandemic, we have different rules in play. And when those rules expire with the states of emergency, how you see this settlement potentially affecting medicine in other states, including places like Louisiana, where assisted suicide is not legal, and remedies and protections that patients of yours and others may be able to avail themselves of.
Thank you, Mr. Vallière. First of all, just by way of introduction, I'm actually sitting in a hotel in Baton Rouge, Louisiana, having just testified in the legislature about an hour ago on other matters. I have doffed my suit coat, and I'm now sitting before my camera in a powder blue shirt with a yellow tie and some dark suspenders. Behind me is an abstract painting, not of my choice, which contains a number of swirls of color depicting an unknown phenomenon. I'm wearing my reading glasses. There's some glare across the screen from the open window to my left. And so I will proceed. Would you like me to speak from slides?
You're welcome to do that. Sure.
Okay. Do you have those to pull up for me?
I can. Let me see here. Yep.
Thank you.
Sure thing. You just let me know when you want to advance the slide.
Sure. And on your computer, can you take that to the slideshow icon in the lower right hand of your screen? So it'll show, or there you go. Good. Thank you. So my slides are put on a PowerPoint medical template. The caduceus is in the middle, and the background is various shades of purple. My main slide titles are in a gold yellow in all caps. And the remainder of my text is bold white on a purple background. The title of the first slide says Physician-Assisted Suicide Across State Lines, the Potential Impact of the Removal of Residency Requirements. It has my full name and titles. Next slide, please. So just by an interesting historical precedent is that in 1829, a long time ago, New York became the first state to actually outlaw assistance to suicide. Next. And presently, 44 states actually have statutes that criminalize assistance to suicide. A broader categorization of the phenomenon which subsumes physician-assisted suicide, I think. And in general, if you look through those statutes, they define this as the provision of intentional aid, advice, or encouragement to a person committing suicide. And that can include both essentially methods and means. Next. It's important to note, I think, that if you survey the legislative landscape, although 44 states outlaw assistance to suicide, only 6 states have an explicit statutory prohibition to physician-assisted suicide. They're listed before you with the statutory references, but the states are Arkansas, Georgia, Ohio, Rhode Island, South Carolina, and Virginia. Next. So Ms. Janssen has covered all of this pretty well. I think one of the important things to point out is that when Oregon and other states have legalized assisted suicide, they have generally done that by carving out physician assistance as an exception to the laws of homicide or what other methods outlaw assistance to suicide in the more general population. And they declare this act of giving someone lethal drugs in doses that are literally 1,000 times the usual therapeutic dose to be medical practice. Forward next. And it's fascinating to note that to this day, assistance to suicide remains a criminal act in Oregon. So we have a situation where we have a statute that outlaws assistance to suicide, but legalizes an exception to it. And that is generally the case in all states that legalize physician-assisted suicide. they carve physician-assisted suicide out as an exception to the laws criminalizing assistance to suicide. And I checked, and the states that presently authorize physician-assisted suicide, almost all of them continue to statutorily define other assistance to suicide as a criminal act. Okay. So, and Ms. Janssen touched on this, but basically all U.S. jurisdictions that authorize physician-assisted suicide presently have a residency requirement. Next. And she already explained what has happened in Oregon, so I won't touch on that again. Next. It is interesting, let's go next. So I went into the Oregon statute, and before I do that, let me say that the Compassionate Choices organization has presently, or did have when I looked 2 days ago on its website, 3 separate documents giving advice to what this means. And it's fascinating that those documents are dated on the 25th of March, before the settlement was actually filed. But they are currently recommending that all aspects of the Death with Dignity Act in Oregon occur entirely within Oregon. So that would be the initial patient interview, the subsequent consultation, the writing of the prescription, the dispensing of the prescription, and the taking of the drug. And they're presently recommending that all of those occur entirely within the state of Oregon. Next. They also are recommending that presently the patient and the physician be physically located in Oregon. Next. That patients receiving telemedicine services also be physically located in Oregon. They are presently recommending that. Next. And that the patients be advised to ingest the lethal medication within the state of Oregon. Next. So if you go into the statute in Oregon and you look at what the residence requirements apply to, and if you remove those, what that means is that any patient anywhere who meets the other requirements for the statute could become what the statute calls a qualified patient and able to avail themselves of the act. Next. Any patient anywhere could make the required written request and the required oral request for these lethal medications. There's no residence requirement that they be in Oregon per se to do that if the present law is waived or modified. And interestingly, and I think beyond what we've discussed, if you read this act carefully, it actually allows the pharmacy to dispense the lethal medications to an expressly identified agent. So in other words, the patient doesn't have to go to the pharmacy to pick the drugs up. The patient can designate an agent to go get the drugs. That raises fascinating requirements, fascinating situational possibilities once the residency requirement is removed and the patient no longer must physically be in Oregon under the requirements of the act. Next. Let's talk about telemedicine, and I'm going to, as Mr. Reynoldson pointed out, the COVID emergency has really muddied the water on telemedicine in most states and at the federal level as well. And I'm not going to try to parse through all of those emergency waivers because many of them are now expiring, and it's thought that the federal waivers will also be removed in the not distant future. So if you go to the Federation of State Medical Boards, who have significant resources on the question of telemedicine, and look at their reports, they have a model policy for the appropriate use of telemedicine available on their website. And so they define telemedicine as the practice of medicine, but using an electronic communication or other means of information technology where the doctor or the licensee is in one location, the patient's in another. Next. That it typically involves a secure video conferencing technology, and it tends to replicate a physical interaction between a patient and a physician. Next. Next. So it addresses several things. One, can you establish a physician-patient relationship by telemedicine? In Louisiana, we have a requirement that to establish a relationship in order to prescribe or dispense opioids, that first visit must be in person. But if you look at telemedicine rules in other states, that does not exist in all states. And so the Federation of State Medical Boards says that basically when there's not an existing physician-patient relationship, the physician must take the appropriate steps to establish that relationship. And that includes, for instance, clearly identifying themselves, making sure the patient understands their identity, gaining the patient's consent to the remainder of the interview, appropriately recording the interview in the medical record, identifying the patient clearly, and then all of the other things that would fall in a usual physician-patient interaction first time. And they generally say that using telemedicine to establish such a relationship is acceptable as long as it meets those standards of care. Next. At the licensure, it's an interesting take on things. Basically, it is the position of the Federation of State Medical Boards, and I think of all state boards in the country, that where the patient is physically located defines the state in which the medicine is practiced. For instance, in Louisiana, if we have a patient who is sitting in Baton Rouge, Louisiana, who has a telemedicine consult with a neurosurgeon at the Mayo Clinic in Minnesota, that is Louisiana medicine. What that means is that the physician who renders that care must have a Louisiana license. They may be primarily licensed in Minnesota, but in order to provide telemedicine care to a patient physically located in Louisiana, they have to have a Louisiana license. Next. And so what that means is even if a state like Oregon or Washington to follow or others removes a residency requirement within their physician-assisted suicide statutes, dual licensed physicians in those states could provide telemedicine services in non-assisted suicide states only at legal peril, because they would be subject to the laws and statutes of the state in which the patient is located at the time the services are rendered, and to the authority of the governing medical board of that state. Now, I will say this, and I've thought about this a good bit in preparation for this. It will be interesting to see if physicians attempt to parse this out. For instance, and if we have the first step in the process is for the patient to make a written request and be seen by a physician on the question of whether or not the patient is actually terminally ill. Now, if you strip away the intent to commit suicide to follow that, that's a medical service that could be rendered under telemedicine today by any dual licensed physician. Likewise, this consultation that follows, in which you have to determine whether the patient has capacity to make decisions and does not have a mental condition which would impair judgment, that can be done by telemedicine very legitimately if it's not part of a physician-assisted suicide process. So it gets to the broader idea that assisted suicide includes aid and advice under the criminal statutes, and whether a patient who is seen in telemedicine for otherwise very legitimate purposes, doctor, do I have a terminal illness? Doctor, is my judgment impaired? Whether those would be outlawed because they would be considered aid or advice under a criminal assisted suicide statute, I think is a very open question. Go forward. What is not in question, though, is that if a dual licensed physician sees a Louisiana patient by telemedicine and attempts to then prescribe 15,000 milligrams of morphine and 1,000 milligrams of diazepam and 100 milligrams of digoxin, all roughly 1,000 times usual therapeutic doses, with the intent that the patient take it and die, that would run afoul of the criminal statutes in Louisiana without question. And before I do this last slide, I would also say that Mr. Vallière and I discussed the issues regarding licensure, and there is now something called the Interstate Medical Licensure Compact, which 34 states participate, that allows a streamlined application for a medical license, so that for states that participate in the compact, such as Louisiana, Colorado is a compact state, a physician seeking to get in Colorado, seeking to get a Louisiana license could enter the compact. Basically the Louisiana Medical Board would accept the due diligence that had been done by the Colorado Board in issuance of their license, and Louisiana would issue a compact license without really much other work to be done by the physician. So there are mechanisms in which doctors could obtain dual licensure pretty readily through the Interstate Medical Licensure Compact. Oregon is not a compact state. Washington State is, Colorado is, and Vermont is, and Maine is. Vermont has it under consideration. So there are at least 3 states that are PAS states that participate in the Interstate Medical Licensure Compact, under which gaining dual licensure would be pretty easy to do. Now, I'm going to return to the fact that I pointed out that only 6 states have explicit prohibitions to physician-assisted suicide, and that in the states that have more general laws criminalizing assistance to suicide, there are significant questions that arise. And I think if you look at the Virginia approach, Virginia has basically put into their statutory code explicitly stating that a licensed healthcare provider who assists or attempts to assist a suicide has engaged in unprofessional conduct with regard to the license and is subject to the licensing authority. So Virginia specifically states that this kind of activity is unprofessional conduct and brings the medical board in. They don't have a statute that otherwise prohibits it, but they've defined it as unprofessional conduct. And if states are looking to address this, I think in a fairly straightforward matter, I think that would be a fairly easy ask of most state legislatures. And that's my last slide. And so I'll stop there, Mr. Vallière, and thank you for your time.
Thank you, Dr. White. Really appreciate your insights there and kind of just understanding more fully exactly the laws that surround, especially telemedicine, and how, you know, it would not be as simple as just now all of a sudden assisted suicides immediately and easily available to everybody. I think that it would be most helpful to advocates who have joined us today to dive a little deeper into some of those suggestions on remedies and what can be done now that the situation is what it is. So Dr. White, you're kind of alluding to the idea that maybe legislatures could put forward or advocates could put forward to their legislators a statute not dissimilar from that of Virginia. Kara had alluded to that as well, not necessarily specifically with Virginia, but just putting in place legislation that has consequences. And so if Virginia is it, you know, if that's the model, do you have any of you kind of done a look at those 6 statutes and whether or not any of them you would consider the model?
Well, Matt, I read all of those statutes in preparation for this talk. Some of them explicitly declare physician-assisted suicide to be a felony. As I recall, Arkansas does that, and I think Ohio does that. The Virginia statute relies on its broader assisted suicide statute and then brings PAS in as an unprofessional conduct under their medical licensing board. I think there are 2 different ways you could approach it. One is you could just flat out ask your legislature to make it a felony. And the other one is you could approach it by authorizing the medical board to deal with it.
Yeah, so I guess some of this, both with the statutes that prohibit assisting in suicide and those that explicitly prohibit, you know, medically assisted suicide, that those things need to be enforced. And so, yeah, having relationships with the enforcement bodies, whether they be the medical licensure board or prosecutors in the place where these things are happening, it kind of almost, it requires that they know that this is the case, and that they're looking out for it. one of our physician allied friends, Dr. Ann Hansen, I know she had asked a question earlier, but Annette Hansen, sorry. One of her thoughts has been to have advocacy at both state level and federal level, where as I believe Conrad had mentioned earlier, like controlled substances and the laws that surround controlled substances and how they move across state lines will be particularly important. And one of the reporting body, whatever it may be in a particular state, as to when a controlled substance moves into that state, if there was a flag on the controlled substances, no, this is a prescription for assisted suicide, and that needs to be recorded, then at least physicians would know, like say, if they're treating a patient for psychiatric conditions, that they have access to lethal means, as an example. But also, whether they be prosecutors or the medical licensure boards, obviously those are two different avenues. One, the medical licensure board would be potentially going after and censuring physicians who participate via telemedicine in contradiction to the law. To your point, Dr. White, that they would be at risk of, at least according to the letter of the law, they'd be at peril there. But with regard to, it's when the drugs come across the state lines, what does that mean for prosecutors who are trying to enforce the law surrounding assistance in suicide? Can they go after these physicians in other states that have assisted this person who's now taking this? It would be like, maybe not dissimilar according to the manslaughter statute. I don't know. I'm not a lawyer, but that's a kind of question. Like if say I handed somebody a loaded gun and they cross state lines, they go kill themselves over there, am I going to be prosecuted for that? And similarly, so, in terms of the manslaughter law in particular states, I'm sure it differs from state to state, but assisting in a suicide, can those people involved, whether they be the proxy who goes to pick up the drugs and then brings them to the person, or the prescribing physician, could those people be prosecuted in a state that that prohibits assisting in suicide based on their prohibition in the other state, in the home state where it happens? As a question open to the panel.
I think it's a very interesting question. I think it's something that we'll need to look into in more detail. I mean, just to add something else, as we've talked to, of course, there's also federal controlled substances laws in terms of going between states as well that are at play here. I mean, I think from my perspective, a lot of it would need to tie into how much can you tie that doctor's activities into the home state where the prosecutor is. And I think that's part of why what happens with telehealth, what happens with people who are on the border. And I think this is why Compassion and Choices probably issued that statement to try to calm people and say everything should happen within Oregon state lines, because I think it's sort of the second that things start happening around this process that actually are happening across state lines in a state that bans it, I think that is where you run into this issue. And it's possible there could be some sort of criminal liability depending on how much of those activities take place in the home state versus the state providing the assisted suicide drugs.
The Compassion and Choices advice sheets specifically caution families and others who might accompany a patient to a legal state, accompany them out of the legal state, or assist them in self-ingesting the medication, that they run significant legal jeopardy if they do not keep it all within the legal state. So I think they understand and perhaps anticipate those circumstances.
Mm-hmm.
Excellent. So, I'm just going to turn to some of the questions from attendees.
Matt, I saw a couple on residency requirements I could briefly address. I guess
Please do. Yeah.
So I think there was a question on why, if I could restate why this would not necessarily invalidate other states' residency requirements. So I can go back to that briefly. The biggest reason here is that nothing was litigated in this case. So there is no decision from the court that says that Oregon's residency requirement violates the Privileges and Immunities Clause. They never got to that point because this was all settled behind the scenes without even an answer to the complaint that would have set forth the state's position. The state never took a position on this at all, essentially, in the case. They just resolved it. And residency requirements are defined differently in different states. In Oregon, it was defined in one particular way that I believe used the same definition for power of attorney. Other states where it's defined just as that you are in the state and intend to remain, those types of residency requirements have been upheld in other cases. Again, a court would need to look into that further, but certainly right now there is no judicial decision, there's no court decision that says these things are invalidated, and so none of the other laws are necessarily invalidated. Somebody asked, why did Oregon cave so easily if these requirements may have withstood scrutiny? I don't know. I can say that the short period of time and the lack of any hearings or litigation or even an answer makes it seem as if perhaps something had been arranged ahead of time. I just don't know.
Yeah. Thank you, Kara. We're coming to the top of the hour. I think that as we navigate all this, there are a lot of questions that are in the Q&A that are going to be left unanswered. So we'll do our best to disseminate that among the panelists and work to get responses. And some of those questions may be grouped together and sent out to attendees. We're very grateful for all the panelists' time and their expertise on this. Again, there's a lot of this is so unknown because we don't know how things are going to play out. There are a lot of questions, and it may be how advocates from the other side decide to try to push this, and whether or not there are doctors in other states that try to push the envelope, whether prosecutors decide to enforce the law. These are all big questions, and I think that the thing that most advocates can do would be pass laws that explicitly have consequences, like Virginia's law, for medical professionals assisting in their patient's suicide, and then be alerting your state's prosecutors, the AG, that this has happened. Make sure that they understand that now the residents of your state are at risk of deadly harm, and that there may be opportunities to prosecute if some of these things come to light. But I also think that there's a lot of conversation still yet to be had on what kind of federal and state level advocacy can be done on monitoring controlled substances and on increasing punishments for physician and censure for physicians who act outside of the law of their state, and all of that in order to better protect vulnerable patients and people with disabilities from both deadly harm and discrimination. So with that, thank you all for joining us this afternoon. We'll continue the fight. I greatly appreciate everyone's advocacy, both those on the panel and the attendees. Everyone is important in this battle, and there's no way for us to overcome these challenges if we don't stand together. So thanks so much.